And we're live. Welcome back, everyone. Craig Stager here. And so this is the regularly scheduled live stream that I'm doing on my YouTube channel and Facebook page. You can, most weeks, most days, you should be able to catch me here at 4:30 p.m. Central Time. I live stream for 30 minutes, give or take. And I try to do a deep dive, kind of a sort of a deep dive into a small topic. But I'm also open to questions and we'll try and give answers. Feel free to leave a question or comment in the chat. I can put those on the screen so people can see what the question is. Um, for those who don't know me, I'm a civil litigator and trial lawyer from Wisconsin. That's where my main office is at, Western Wisconsin. But I also am licensed in practice in Minnesota and Iowa. And most of the work I do involves representing injured plaintiffs, personal injury cases, car and truck accidents, things of that nature. So, with that in mind, before we begin, I have to do the perfunctory disclaimer. I'm going to put that up here for you. This is not legal advice. This is for informational purposes only. If you do enter into the chat, um, if we do interact with each other, please realize that that's not creating an attorney-client relationship. You should always consult with an attorney in your jurisdiction and in the specialty or the area of law at issue to get your actual questions answered. With that in mind, let's go ahead and get started here. So today's topic is lawyer fee agreements. And what does that mean? If you have never had to hire an attorney before, it's not surprising that you would be confused or uncertain as to how lawyers get paid, how much it's going to cost, what do these different types of contracts and fee agreements mean. And I want to try and give you kind of an overview of the different types of ways that lawyers are typically hired. This is not meant to be an exhaustive list, but I think I'm going to go over the 4 or 5 most common types of fee agreements, fee contracts that you can expect if you have to hire an attorney. And in many ways, it will depend on factors such as your geographic region, um, and what type of issue you have, because the fee agreements tend to vary based on practice area between, let's say, criminal defense, personal injury, divorce and family law, things like that tend to have little different structures in place for for hiring lawyers and for lawyers to charge their clients for the work that they do. So I wanted to kind of go over a few kind of key issues or things to keep in mind. So um, you should not be surprised by what a lawyer charges you. What does that mean? If you talk to a lawyer, ask right away, is this a free consultation? Am I being charged for this? I think you will find most lawyers will offer a free consultation to have an initial call or a meeting with you to find out if they can help you and how much that will cost. Some lawyers do not do free consultations. That initial visit, there is a cost, but they should tell you that in advance, and you should know that in advance. In all likelihood, they're going to want that money up front anyway. So, but it's always a good idea to ask the attorney if you've never hired an attorney before. Ask right away. Look, am I being charged and how much? So that you know before you start communicating with them what the charges are going to be. Um, in most situations, attorney fee agreements have to be in writing. Now, it doesn't mean it has to be in paper. It can be an electronic document, electronically signed, sometimes just memorialized in an email or electronic letter or something like that. But there needs to be some sort of a document, electronic or written, setting forth the terms of the fee agreement, how much it's going to cost, how the lawyer is going to be compensated for their time, their staff, reimbursed for expenses, things like that. So typically, fee agreements are going to be in writing, and it's a really good idea to ask that your fee agreement, that the terms be put in writing before you commit to hiring an attorney. In most states and most jurisdictions, it's required by the rules of ethics that we all abide by, or required to abide by, that most fee agreements be in writing. The exception is if you're doing work and it's not expected to um, cost above a certain dollar amount. I think in Wisconsin it's $1,000, uh, give or take, but that's sort of one benchmark. If it's going to only cost a few $100s, that it be put in writing. Um, some fee agreements have to be in writing regardless, and I think contingency fee agreements are one example of that. And I'll talk about that a little more. Um, a few things that you will probably hear about is referral fees, and what does that mean? So it's common in the practice of law for someone to contact a lawyer. Maybe it's someone you know, maybe it's a lawyer you've worked with before. You have some connection, and you reach out to them and say, "Hey, I got this new problem," or "My son or daughter was involved in a car accident, but you did my will for me. Can you help me?" It's very common for lawyers to refer people to other lawyers who specialize in the type of work, and vice versa. And and in most states, they will probably be required to disclose this to you. But lawyers are actually allowed to share fees with each other, and to provide a referral fee to another lawyer for referring cases or referring work to other lawyers. In the most states, I believe there's a couple of exceptions, and maybe Arizona and Utah. I'm not entirely sure, but in some states, it actually is legal to share fees with to provide referral fees to non-lawyers. But in most states, most jurisdictions, referral fees can only be shared with lawyers, and they may need to be in writing and disclosed to the client. Trust accounts. What are trust accounts? And trust accounts are sort of that sacred piggy bank that every lawyer or law firm, or most, are going to use to handle client funds. Now, that could be money that's paid in advance for work. It could be money that the client deposits there to, let's say, to close on a house or a property, or maybe they've sold property. And so the trust account is that sort of sacred, untouchable uh, account that's only client funds. The lawyer or law firm may not use those funds for their own operational expenses, may not borrow against that. If you do, that's a big no-no. So trust accounts are where a lot of times fees that are paid up front, are held until the work is done, or until the work is performed and they're billed against it. Or if there's a personal injury settlement, a lot of times that money will come into a trust account, be divided up, and then checks written from the trust account to the client, to other lawyers, to healthcare providers. Sometimes insurance companies are entitled to reimbursement. Um, and the other thing to keep in mind is that there are ethical rules. This will vary by state, but they're fairly similar. Is there are some ethical rules that apply to fee agreements, and not even just fee agreements, but what lawyers charge for the work that they do. Probably one of the more important ones is that the fee must be fair and reasonable. It's not enough that the client agrees to pay a certain amount or a certain percentage for work that is done. It actually has to be objectively fair and reasonable under the circumstances. So lawyers may not take an exorbitant fee simply because the client agreed. Okay, that's one thing to keep in mind. Generally speaking, fee agreements should be in writing, and even if they're not required to, it's a really good practice to have them in writing anyway. Some states put limits on attorney's fees, percentages. Wisconsin, for example, where my main office is at, where I do most of my work, has attorney fee limits for medical malpractice cases. It's one example of tort reform designed to discourage lawyers from bringing these cases. But you can get leave of court for a higher fee if it's appropriate. Um, let's see. A few other things that can complicate it. If in some cases there may be a claim that includes an attorney's fee remedy. The general rule in the U.S. at least is that each party pays their own attorney's fees. You don't typically get your attorney's fees paid by the other side if you're a prevailing party in most states and jurisdictions. There are exceptions to that. There are specific rules and statutes that can allow the court to award attorney's fees. Some examples might be discrimination cases, racial, religion, sexual orientation, things like that. Um, Wage cases, oftentimes there will be an attorney's fee remedy built in. And why is that? Well, it's typically there to incentivize people to enforce their rights, even when the dollar amount that they're claiming may not, in and of itself, justify the cost that it takes to hire a lawyer. And in some cases, it may cost more in attorney's fees than the person can actually recover. And the attorney's fee statutes are there designed to um, to not allow bad actors to kind of get away with things because it would be too expensive for someone to hire a lawyer to get back what's rightfully theirs. So that can complicate fee agreements as well. And there's other examples, but those are kind of some of the big kind of general principles to keep in mind when it comes to lawyer fees and fee agreements. So, what are the different types of fee agreements? So, the one that I'm most familiar with is a contingency fee agreement because most of my work, not all of it, but most of my work involves representing injured people, personal injury type cases. Most, and I would say the vast majority of these kinds of cases are brought on a contingency. What does that mean? That means that the lawyer only gets paid if there is an actual recovery, which means that if you lose, the lawyer's time, their fees, is not compensated, and what they are paid is generally a percentage of whatever they recover, whether it's by settlement, arbitration, a jury verdict, whatever the case may be, it's a percentage. And in, I would say, most areas, a very common percentage is anywhere from about 30 to 40%, sometimes higher than 40%. I don't see a lot of contingency fees that are less than 30%, although I do see them and I use them at times, and I'll talk a little bit more about that later. For example, sometimes I'll have a client come to me who had bad injuries, and we already know that there's not going to be enough insurance, which means that there's a decent chance that the insurance company may pay their policy limits without a lot of effort by an attorney. And so sometimes in those cases, we will adjust the fee so that if we can settle the case without filing a lawsuit, it's this percentage. And then if we have to file a lawsuit, it jumps to this percentage. And in most fee agreements, if there's an appeal, the percentage goes up again. And why is that? Well, because an appeal can be very time consuming, and if successful, generally means another trial or another lawsuit. And so that's why the percentage jumps up typically in most contingency fee agreements if there's an appeal. One of the most important things that people should be aware of when it comes to contingency fee agreements, and this is something that I really emphasize with my clients, is what about case expenses? What about costs? Because contingency fee generally speaking, refers to the lawyer's time. That's their fees, but not case expenses and out of pocket costs. What do I mean by that? Well, usually during the course of litigation, especially personal injury cases and things like that, the lawyer law firm will actually advance costs that it takes to actually bring those cases. To give you some examples, medical records. If we get medical records from a hospital, they will charge for those records. We will simply pay them. If we file a lawsuit, there's almost always a court filing fee. We'll have to pay the sheriff to go out and serve papers. Um, if you get into the lawsuit, depositions sometimes get taken, and then so you have to pay court reporters for their work and to get copies of transcripts. A lot of times you have to hire expert witnesses. They don't work for free. We simply pay them or advance them. Those are case expenses or costs associated that are separate from the lawyer's time and generally are not included in the contingency fee. So uh, uh, every fee agreement's a little different. It's really important to ask about this when you're going to hire an attorney because even if you lose, the lawyer's fees may not there may not be anything owed for the lawyer's fees, but you may still owe them for their case expenses and costs. Or if there is a resolution, if there is a settlement, you should realize that the contingency may apply may let's say applies to the fees, but in addition to that, then also is reimbursement for those case expenses, which sometimes can be significant. And depending on the fee agreement, those case expenses may come off the top or may come off after the lawyer's contingency fee is paid. And I'll show you an example here in a moment. There are some there are some types of cases, and this is generally set forth by ethical rules that you cannot do a contingency fee on. I believe examples are criminal cases. I believe in most states, divorce cases can't be done on a contingency fee agreement, so you can't do it for the lawyer can't do it for a share of the assets or share of the child support and things like that. I think that's true in most jurisdictions, but I don't do family law, so I can't say that with absolute certainty. Um, but so let me give you I'm going to show you an example of case that I recently settled. I've blotted out the names of those involved just to for obvious reasons, but I want to kind of show you how it works. So contingency fee is, like I said, percentage is for the lawyer's time and efforts, as well as all their staff, paralegals, all that kind of stuff, overhead, and then after that is case expenses. These are amounts that we, as the lawyer or the law firm, have actually paid out to do the case and to do it right. Court filing fees, medical record copy charges, expert witnesses, things like that. Things I already kind of mentioned. Well, when there's a settlement, that's where this contingency fee agreement works out. And then what happens is we basically divide up the gross amount to pay the lawyer's fees, case expenses. Sometimes there are subrogated parties. I'll show you that in a moment. But let me show you a case that I recently resolved. I'll put it on the screen, and then I think I'll get my face out of here. There. So this is a personal injury case I recently settled for $75,000. This was done on a 40% contingency, probably because it was a trip and fall, and they tend to be more difficult to prove. Okay. So so the gross amount was $75,000 because we were successful, and 40% of the $75,000 is our attorney's fees, $30,000. Now, no, this case was referred to me by another lawyer, and so we split that 40%. The client doesn't get charged more because there's a referral fee. It's just that the money gets divided between the lawyers themselves. And so in this case, I divided that between our firm and the lawyer that referred the case and actually was involved in the case. So that's how the contingency, this is where the contingency comes in. Now, after that, our case expenses, and you'll see there's two lines for case expenses because both my office and the other lawyer's office advanced case expenses. He filed a lawsuit. So this is probably $228 is probably what it cost to file the lawsuit. And then I was brought into the case. And you'll see here, there the case expenses are over almost $11,000. Now that's a little higher than usual, but it's not, it certainly isn't unusual. And in that case, that involved hiring two experts. One was a medical expert because the treating healthcare providers for my client were not necessarily uh, they were not either cooperative or were difficult to get a hold of or wouldn't testify at trial. So we had to hire an expert. I pay for that. Our firm pays for that. And the other one was a safety expert who talked about the unsafe sidewalk that caused my client's injuries. Um, and then you'll see here there is an item for a reimbursement to BCBS, means Blue Cross and Blue Shield. That's a subrogation. We were still working on that, so we advanced. We held back some of the money until we got them paid off, and then typically the client will get an additional check at the end, and then the client approves and signs it, and then we go ahead and issue checks accordingly. This is called subrogation. That's very common. So usually, if people are involved in an accident, they will have health insurance. Sometimes it's med pay and car insurance will pay medical expenses, and then they're entitled to reimbursement, or it's called subrogation out of any settlement. And that's what this is right here. That we had to have to repay them. Okay, so that's sort of an example in practice of how a contingency fee agreement works in practice. So I'm going to take that down. Okay, so that's a contingency fee agreement. So what are the other types? And I'm going to go kind of quickly over these other ones because I want to make sure we're done here in 30 minutes. So another one is what's called a retainer agreement. And retainer agreement tends to get is sort of loosely used to describe all fee agreements, but retainer agreements are actually a very specific type of agreement that in my experience doesn't actually get used very often. I don't use retainer agreements. In the technical sense of the word, a retainer agreement means you pay a lawyer or law firm a certain amount of money to become your lawyer. And I don't believe in most cases that involves the actual work that the lawyer or law firm is going to do. That's charged separately. Maybe it's hourly, whatever the case may be. So retainer agreements are actually just the cost of getting the lawyer or law firm to agree to do work for you at all, and then they pay you. Then you pay them for the work that they actually do. So in my experience, retainers are not actually very common, even though a lot of times we'll refer to contingencies or hourlies or flat fees as retainer agreements. So what are the actual common types of fee agreements? So other than a contingency, one is an hourly fee agreement. And this is probably, I would say, the traditional way that most lawyers charge for their work is so much per hour, billable hours. You do 10 hours worth of work, it's 10 hours times your hourly rate. That's what the client pays. A lot of times it's billed monthly or over some other period of time. It's just whatever time the lawyer spends, the client is charged for that. I would say that's becoming less and less common in today's age, but there are still, I would say, a lot of work that is done on a purely hourly basis. Let me see here. One of the things I would say that a lot of times hourlies, like personal injury is typically done on a contingency fee, but a lot of times other types of civil disputes, maybe it's a boundary dispute, maybe it's a business dispute, family law, criminal. A lot of times that work is done on an hourly basis. And one of the reasons it might be done on an hourly basis is it's hard to predict exactly what what the work is going to involve and how complicated the case is going to be. And so we simply do it as we do it on an hourly basis as the work is required. Um, an advanced fee agreement is sort of, I would say, the more common fee agreement other than contingency fee agreements. And so an advanced fee is like an hourly agreement, at least the ones that we use, which is it's money is paid up front, and then it's typically deposited into that law firm's trust account and it stays there. And then the lawyer will do their work, let's say on an hourly basis. Okay. Then the lawyer will do their work each month, and then they will basically charge the client by taking some of the money out of the trust account and applying it, paying themselves the money out of the trust account that was paid in advance. Okay. Advance fees may or may not represent the total expected cost of the work, but it is sort of that idea, like lawyers sometimes want or need that security. They get some money up front before they actually start doing the work. So that's what an advance fee agreement is. I believe most advance fee agreements, if not all, have to be in writing, but maybe not if it's going to be under $1,000. I'm not. You'd have to check with the lawyer in your jurisdiction to find out for sure. So what's the other? So the other, I would say, becoming more common fee agreement is a flat fee agreement. And I personally don't have any experience doing flat fee agreements because that's not the type of work that I do. But I know it's becoming more and more common in certain types of work, such as, let's say, I think a lot of criminal defense cases are done on a flat fee now. Let's see, OWI tickets, things like that. More and more family law divorce cases are being done on a flat fee, but it might just be for uncontested cases. I would say a lot of like transactional work, like preparing wills, estate plans, trusts, things like that, more and more are being done on a flat fee basis, which is appealing to both the lawyer and the person hiring, because you know exactly how much we're going to pay and what we're going to get in return. I think we're going to see more and more work going towards a flat fee model because it is so attractive to clients, and it's easy for the lawyer. Doesn't have to be worrying about timesheets and billing hours. They just do the work and then they get paid for the agreed upon amount. Not everything works for flat fee, and it can at times result in paying more money for the lawyer's work because the lawyer may err on the high side of a flat fee as opposed to an hourly agreement. So flat fees are nice in that they are predictable, but you may find that that you pay more in some cases than you would on a purely hourly basis. So you want to check with that and talk to the lawyer and find out what is actually going to be involved here. Can I do it on an hourly basis? If so, how much will that cost? It's at least something to consider. Let's see. So a few things, pointers, things to keep in mind. If you're looking to hire an attorney, is find out right away what they charge, what are the terms. Read the fee agreement carefully and talk to someone else or find another lawyer if you have questions about it. Ask questions, and if possible, ask questions in writing, so maybe an email, so that you're crystal clear on what is and isn't um, um, contained within the fee agreement and how it works. It might be a good example to ask for an example similar to what I showed you before in a recapitulation after a case is settled. Maybe ask them to draw it out and show how it would work in practice. Ask around. talk to different lawyers. You may find different lawyers and law firms charge different things for the same work. And one thing that I would emphasize is this: um, cheaper isn't always better. And generally speaking, not always, but generally speaking, the most experienced attorneys are going to charge the highest rate, but may actually get the work done more quickly because they have so much more experience. So do your homework, check around, ask around, compare, do what you got to do to make sure that you're comfortable with what is your financial obligations for the legal work being done. Let me see here. I think that kind of covers everything that I wanted to cover. So I appreciate everyone who. I don't think anyone was on this live stream, but anyone that watches this later on, I hope you find this helpful. If you do have questions about any of it, feel free to leave a comment. I do pretty good at following up on comments. You can always send me a message if you want. You can email me. Go to www.craigstager.com. That'll take you to my link tree. You can call or text me. That's my Google Voice number. You can send us a text message if you want. Yeah. What else? I hope you enjoy these. I enjoy doing these, and if you had a question that didn't get answered today, it may or may not even be related to the topic. Just stay tuned to the next time. I do these pretty much every weekday at 4:30 p.m. for 30 minutes, so you'll have other opportunities to have your questions answered, and it doesn't have to be related to the topic that I post. That just means that um, unless someone comes in with questions, these are the things I'll plan to cover in the live stream. So you can always ask questions, whether it's related to the topic or not. I appreciate everyone for watching. I appreciate it if you would subscribe to my channel, follow me on Facebook and the other social media channels. If you'd like more of this content, I do appreciate you watching. And until next time, everyone, have a good one.